Holland Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Hello, everyone, and welcome back to the latest episode of our AI and Legal Professional Privilege podcast. Today's episode is part 2 of my discussion with Ian Clark-Fisher, partner at United States firm Robinson & Cole in New York, in which we discuss how AI is impacting legal professional privilege, focusing on how the issue is being approached in the US, including how this compares to the current position in Australia. For those who tuned into part 1 of my discussion with Ian, we discussed the judicial system and privilege in the US, and how that compares to our Australian system, our form of privilege, and the definitions adopted by Australian courts. We then moved to consider a key decision of the Southern District of New York from earlier this year, specifically the decision of United States and Heppner. Now, this Heppner decision was the first case in the US that addressed AI and attorney-client privilege, in which the court ultimately ruled that documents generated using the publicly available AI platform, Claude, were not at the direction of counsel and thus were not protected by this privilege. It was therefore held that in this instance, the Claude-generated materials must be produced, as the specific facts of that case did not support work product protections. Now, interestingly, while Heppner was the first decision of its kind in the US in this space, more recently, there really has been an evolution. Let's see what Ian has to say about the post-Heppner position of the courts, as well as us discussing the judicial guidance released by both the US and Australia in ultimately examining prospective next steps regarding the use of AI in litigation. Now, let's move from our discussion of Heppner to the cases that followed.
That's, again, leading us into our next discussion for a case that has been relied upon and referenced quite a few times, is a decision of the Eastern District of Michigan, which reached quite a different conclusion with respect to similar issues in terms of the use of AI and its effect on privilege, but with a very different factual matrix. And that's the decision of Warner and Gilbarco. And that was an instance where a federal magistrate judge in the Eastern District of Michigan ruled quite differently to Heppner. And again, here this was with respect to a pro se, or what we in Australia called self-represented plaintiff, and their use of AI-assisted materials. So that is quite important to factor in, and this is something you and I have spoken about before, Ian, that there is quite a line of thinking and rationale about pro se litigants using AI and whether that changes the sphere of things. And it does. When we look through the cases to come, the self-represented litigant is treated differently than they were in Heppner, but that's also, as we said, a factual situation. Yes, would you like to speak to Warner and your thoughts on Warner, Ian?
Sure, yeah. I mean, so this is a case where this was an employment dispute and corporate defendants were seeking a pro se plaintiff, an individual who self-represented individual. They were seeking the production of his use of ChatGPT. Again, this was a, public AI, not closed. And in this instance, the other side of the coin from Heppner is the court found that the information on ChatGPT was protected by the work product doctrine, which a pro se party was permitted to assert. And interestingly here, and this kind of goes to our tool conversation, the court explicitly found that ChatGPT was a tool, not a person, right? So it wasn't that they took the position that the pro se party was not disclosing this information to a third party, which would arguably waive the doctrine, but rather that they were using ChatGPT as a tool. And I think the timing of these cases is interesting, right? Because they came out in the same week. I actually think Warner may have come out a couple of days before Heppner. But so there was no interplay between the two cases, right? Different jurisdictions, they weren't aware of each other. There's no discussion.
No, I don't think so. My understanding, and I welcome being told otherwise, but my understanding was that Heppner, perhaps the judgment, the orders were released perhaps first, and then Warner was, I think, heard prior, but there was only a space of days in which Heppner may have been released or decided slightly earlier or something, but it was within a few days, and I don't understand that they had regard to each other, but dealt with very similar issues in quite a different way.
Yeah, no, I'm not entirely sure which one was made publicly available first, but they're not communicating with each other, so to speak. They weren't, there's no reference to each other, and they're really both kind of cases of first impression in that sense that land very differently, in my opinion. And
Yes.
while there are factual distinctions for sure. If you're thinking about broad legal principles, one found that the the work product doctrine does apply to an individual use of a public or open AI platform, and the other decided that it was protected, or vice versa.
And interestingly, I think in Warner, I thought it was very significant that it was decided that the plaintiff, and again, self-represented pro se plaintiff, but she was in effect acting as her own counsel. And I thought that really comes back to that point made in Heppner of, in that instance, Heppner had counsel, and therefore it could not be captured that his work, if you'll call it, or his use of AI could fall under that broad brush banner. I also do think a comment that was made in Warner that seems to come up, and again foreshadowed in other cases, but is that if you were to waive the work product doctrine, is the work product waiver has to be a waiver to an adversary, or in a way likely to get into an adversary's hand. So I do think comments to that effect are raising the bar and changing the interpretation of how we see privilege, because I do think it's quite interesting to differentiate between the level of what the waiver and to whom the information is being disseminated, rather than making it quite a broad brush understanding.
Yeah, no, I completely agree with that sentiment.
Yes, great. So then we've got another case that came out not very long after, just in March. So again, really, there's been a flurry in my understanding from February to now, to July. We have the case of Morgan and V2X Incorporated that was quite influenced by the Warner decision before it, the recent Warner decision that we've just discussed. And that was a decision of the United States District Court for the District of Colorado. So we're seeing a lot of different cases and their positions here. Here we again have a pro se plaintiff who, again, an employment situation where a pro se plaintiff, Mr. Morgan, sued his former employer, V2X, for employment discrimination. And during discovery, I understand that a dispute arose over Mr. Morgan's use of artificial intelligence tools to handle confidential discovery material. I thought it was quite interesting with this case in that V2X, the defendant here, sought to amend specific protective orders to regulate AI use and to require the plaintiff to disclose which AI tools he used on the basis that they had confidentiality concerns, while Mr. Morgan again objected on work product grounds. So I thought this was quite an interesting discussion about the practical use of AI and the confidentiality attached to even the disclosure or use of AI. And interestingly, again, this court, I understand, relied on that point of providing information that does not constitute disclosure to an adversary. So the level of disclosure and the breadth of disclosure, rather than just the existence of any disclosure, was something that was considered by the court.
This is our kind of the more fulsome development of this case law, right? The Morgan decision comes after Heppner, comes after Warner, and does specifically address both of those lines of thinking, and seemingly aligns itself with Warner. Now, granted, it's a somewhat similar set of facts in the sense that there's a pro se or self-represented litigant. It does find that the work product doctrine can apply. It also, I think, does a nice job, and this is courts are respectful of each other, of differentiating itself from Heppner by saying that this is a civil case, it's not criminal, so different rules can apply. And that whereas in Heppner, there was this gap between the individual party and their attorney, here that doesn't exist because, again, this is pro se, similar to Warner. Then it goes to a next step where it talks about what protections could exist with the use of an open AI or public AI, and it amends the protective order. I think this is interesting going forward. It amends the protective order to limit what could be uploaded to a public AI, right? So if there's a protective order in place, certain documents that would be disclosed during discovery could be designated confidential, and it places limitations on the use of what's been designated as confidential to be uploaded to a public AI. And I think it's an interesting decision because it really highlights, I think the court does a nice job at talking about how monumental the use of AI could be for a self-represented party. And not just for a self-represented party, actually, for anybody, but really for a self-represented party, because it can help foster what a brief would look like, what legal arguments could exist, and things like that. And it highlights this benefit, while then at the same time placing some guardrails on how a self-represented party could be using AI. But as a general principle, I think Morgan is a helpful guidepost because it aligns itself more with Warner than it does with Heppner.
I agree. And I do think that, and I think, again, there's your comment about protecting the self-represented litigant, I think it really rings true, because there's a specific carve out in the amending of the protective order and in this judgment for any information and the reveal of any information that would allow the self-represented litigant's mental impressions or legal strategy to be revealed, because that's, again, we're coming back to the notion that this self-represented litigant is acting on their own behest, and therefore their mental impressions, consideration, strategy should be protected. And that's something that I thought was a very significant carve out from Morgan. And in amending a protective order to specifically address the AI use in this case, I thought that this decision, as with Heppner, but this moved the dial even more, as you foreshadowed, toward a more functional, risk-based approach to AI use, rather than being quite a blanket position that is reflected along the cases. I think it signalled a change, in my understanding, in the case law, in that the horizons were quite open for courts to really take the use of AI and tailor what is best for a self-represented litigant, for counsel, for whomever, in their protection of privilege and confidentiality.
I think that's right. And again, I think this case is also the first time that a court can consider other decisions. So I think they have the benefit of being able to look at how other courts have addressed things and are adding on, which is obviously how the US case law works.
Yes. And on that note, we've had quite a few discussions also, Ian, about there's been a breadth of case law between the Warner and the Heppner and these decisions and to date, but we wanted to focus on a couple of more recent ones, because as you foreshadowed in our discussions, some of these more recent have been even more practical for litigators in the day-to-day. But the first recent significant case, again, that we'd like to discuss is the one of Assini and Haywood, which I understand is a New York Supreme Court decision, which considered whether a litigant's ChatGPT and OpenAI records could be obtained through a subpoena served directly on OpenAI, which, again, has gone further in trying to protect AI-assisted preparation. So in that decision, I understood that the plaintiff sought extensive disclosure of the defendant's ChatGPT prompts, uploaded documents, queries, outputs, and other AI-generated materials relating to the litigation. And interestingly, the court in Assini accepted that materials generated through a litigant's use of AI for litigation preparation, again, may attract work product protection. And as you foreshadowed again, the court has favoured the rationale in Morgan, which, as we know, held that a pro se litigant's interactions with AI can resemble confidential strategic litigation preparation, and therefore can fall within the type of work product that discovery rules are designed to protect. So interestingly, the court here rejected reliance on Heppner and went down the Morgan route instead, which is something that we've foreshadowed in our discussions, Ian, so far.
Yeah, no, exactly. I think this is the new line of thinking. But again, it's still a pro se litigant, but right, it is adopting the Warner Morgan line of decision in protecting use of public AI based on the work product doctrine. I will say, just for those listening, New York Supreme Court is New York's trial level court. So it is only for those listening in the sense of the U.S. Supreme Court is the final court of appeals. This is still a trial court decision.
Thank you. We and I speak on behalf of Australia, obviously, as I'm entitled to do, but I appreciate the clarification, because it is very interesting to see the different states commenting, and it's that context as to which level everyone sits at really does help clarify where these decisions are coming from. So thank you for that. The case that I think follows Assini, and the one that you and I were eager to discuss, Ian, is the matter of Tate Group Automotive and Legacy Automotive Capital. And this is a Business Court of Texas decision. And now please tell me, where does the Business Court of Texas sit in relation to the fabric of the judiciary?
My understanding is it's a trial level court in Texas. I do not practice routinely in Texas. Every now and again, but yeah, I believe this is a trial level decision. And right, and as you mentioned, I think this is I believe this decision came out in June, right? It's a June 3rd decision.
Yes, it's June.
It's just a minute entry, right? So it's not that developed of a decision. There's not a great deal out there about the decision. But what I think is so interesting about this decision is this is the first time where the court is applying the work product doctrine to what I would call kind of an ordinary commercial business dispute. It's not a pro se matter, right? These are represented parties. And the court is finding that, moving forward with the Morgan and Warner line of thinking, that this is an individual, a non-lawyer principal of a business that is represented by counsel, was using ChatGPT, and the court found that use was protected by the work product doctrine. And again, it's not that long of a decision. There's not that much background in the decision, in my opinion, but it's the first time, at least that I've seen, where I think this may be the wave of the future. And what this court also does, which I think, again, a lot of the other courts have referenced Heppner and maybe differentiated it. I think this court, it says the court disagrees with the primary authority cited by defendants in support of waiver, right? So it actually takes the position that we disagree with the Heppner line of thinking, that use of open AI, public AI would waive the work product privilege.
I agree. I think Tate really marks what I understand to be the first US decision to apply the doctrine in an ordinary commercial setting, again with a represented party, which is very significant, and where a represented party uses AI as a litigation support tool. So that really does open the door to the use of AI in our sort of day-to-day practice, and how that looks and how that interacts with waiver of privilege, and how that here has been determined to be a support tool. So we go back again to that AI use as a tool, rather than, as Heppner has been disagreed with here, as rather than a third party.
And I think, just speaking from my own experience, I think Tate is a logical extension of what is actually happening in real time, which is that clients are using AI, right? Everyone is using AI. And for better or worse, I do think that there's an expectation, whether it is accurate or not, of some level of confidentiality in that use. And again, I think that that's what we're talking about. Is that expectation valid or not? And I think we will see over time how that develops. But I think some of the cases reference the fact that people communicate using Gmail with their counsel. And right, I think lots of email servers, they pull information from your emails, right? That's how you get directed ads and things like that. But there's still an expectation of some level of expectation of privacy in that. And where does that go with the use of AI? Because I do think that, as I said in the beginning of this conversation, everybody's using AI. And I do think that that is probably more common than we'd like to admit, that our clients, either before or after they're interacting with counsel, are using AI to get their own input as to what they should be doing in any instance.
No, I agree. And I do think that from what we've seen, the courts in the US seem to be increasingly focused on the nuance of how generative AI does affect litigation, and the practicalities as well, as you've foreshadowed. And they seem to show that privilege outcomes consider multifactorial in their consideration in terms of who's used the AI and circumstances, to whom it's disseminated, whether supervision's involved, legal supervision or otherwise, and the terms and conditions of the specific platform. And I really welcome a decision in Australia, an authoritative ruling that considers these points, because at the moment we've had a lot of Australian cases that have highlighted instances of lawyers and litigants filing hallucinations and AI generated hallucinations, false citations, reliance on incorrect or non-existent materials, but we haven't seen an authoritative nuanced ruling regarding the uploading of documents to AI tools or what equates to a waiver of privilege or anything of that note. We have had a few Federal Circuit and Family Court decisions late 2025. Again, the instances of self-represented parties. So we're not getting back into that realm that we've discussed with Tate of really commercial sort of dictum and situations that we can actually then extrapolate to our use in day-to-day litigation. But what we have seen is decisions like Helmold and Maria, which was a decision of the Federal Circuit and Family Court late last year, where the court endorsed recent judicial warnings about AI use and emphasised practitioners' professional obligations to verify all material filed. In that instance, the court observed that inputting court documents into open AI systems may breach statutory prohibitions on publication, may undermine confidentiality, and may potentially waive legal professional privilege. Now, again, it's a caution at most, and these concerns were reinforced in a subsequent decision late in 2025 of Mertz and Mertz number 3, in which the court here reiterated the risks identified in Helmond, the previous case I've mentioned, again, including potential breaches of statutory confidentiality provisions, the harm and undertaking, and a waiver of privilege where documents are entered into AI. And reflecting the seriousness of these issues, because these issues are taken seriously, but the court here referred the practitioner's conduct to the relevant professional regulatory bodies. So we haven't had too much judicial consideration in the way that there has been in the US. But what we have had in Australia is a wave of practice notes, judicial practice notes and judicial guidance issued by Australian courts, specifically this year in response to the growing number of practitioners using generative AI and the growing use of it and reference of it in legal proceedings. So we've had a very significant Victorian Law Reform Commission, which is an overarching sort of regulatory body for practitioners in Victoria, in one of the states in Australia. They prepared a specific report that contained 30 recommendations and 8 suggested overarching principles to guide safe use of AI and maintain public trust. And a lot of those recommendations, and specifically those 8 overarching principles, have been adopted in the 5 months since that report was tabled, with 4 courts having issued formal guidance on the use of this generative AI. And that's both a mix of state courts and federal courts. So we have seen a lot of movement in this front, and there do seem to be specific clear trends, with courts distinguishing between public and closed AI. Courts users ultimately remaining responsible for the verification of the AI generated content, and this overarching need for the safe use of AI as being the permeating factor between all these various guidances. So where we haven't had as much movement in terms of decisions, the courts have tried to stopgap this with practice notes and judicial guidance. Have you had things like this released in the US, Ian? Have you had overarching regulatory guidance? And does it exist in the US? I understand that there is some within the states.
Yeah, I think, again, every court kind of has its own practice. But I think overall, the guidance and the regulations are almost identical to what you're suggesting, which is that the courts are generally allowing AI use. They're acknowledging that it exists, but they're requiring attorney accountability, right? So, and again, this is addressing the hallucinations and things that made the news in 2025. If you're using AI, there's some judges' individual rules in some courts that require you to disclose the use of AI, even the specific platform that you're using, but to disclose the use of AI and to certify that you've verified what you're actually filing. And as a practical matter in federal court, there's something called Rule 11, which pretty much requires counsel to it's your obligation to review what you filed, right? And to make a good faith effort into filing a decent argument and a correct argument. And again, that would apply whether you're using AI or whether you're filing a brief that someone else assisted you in drafting, right? It's the same general construct there. And in fact, New York State courts, their guidance, which came out a month or so ago, it
Yes.
was pretty much, it allows use, but use at your own risk, right? Which is again, courts are allowing the use of AI, but requiring accountability. I really think that is the theme, which is you can't turn a blind eye. It's not going to be a defense if you are making a bad argument or including case law that quite frankly doesn't exist. It is your obligation as the lawyer to make sure that you are filing something that's appropriate.
Yes. I wonder whether we'll have an example of a case that comes out where someone tries to blame the AI. I'm not sure, off topic for a second, but I'm not sure if you've seen, Ian, but in the UK again, there was a law firm that's an AI law firm and an AI lawyer, if you will, that actually won a self-represented litigant. Self-represented insofar as there wasn't an actual person, but a person represented by an artificial intelligence lawyer won them a small settlement in court with no actual preparation by any actual person. It was all done through an AI lawyer in the UK. So I wonder if something had gone wrong there, it would have been a reliance on AI and pointing the finger to them. I wonder if, again,
yeah, that's so interesting. I haven't seen that, but I do think, again, talking in the beginning of this conversation about how we're talking about this in its infancy, obviously right now there's nothing suggesting that AI is in and of itself a lawyer. But candidly, I could see this conversation in a number of years being materially different where AI has taken on a different form in our profession. Knock on wood that you and I are still employed at that point, but I do think that this conversation is such, and the evolution is such that's interesting. I had not heard about that case, but it doesn't surprise me at all.
It was a very low quantum. I think it was about £10,000 or something, but it's a very interesting way of the world. And so in the UK, I just do find it interesting what they're doing there, because they've got AI lawyers running cases, and then they've also got dictums coming out that say that if you don't use AI, you're potentially opening yourself up to criticism or to some sort of response by the courts. So it'd be very interesting. Yet they don't seem to have an overarching decision there that dictates how one should and shouldn't be using. So it's very interesting, I think, to see how the different jurisdictions are trying to grapple with what really is, as you've said, used by everyone. I really am interested to see a future Australian decision, because I really think we'll have a lot to learn from the nuanced considerations from the US, but then also these quite interesting and out-of-the-box uses in the UK as well.
I do think, guys, the future is now. I think it's anybody's guess to see where this is going to go and how the case law develops. I do think this was more and more, right? Not only are we seeing clients using AI, but we're also seeing more institutional, sophisticated clients like requiring that the firm itself use AI as part of its legal representation, right? And that goes to your comment about a UK reference to it. But I do think that we're having this conversation in the beginning, and I do think it's anybody's guess where this will end. Other than that, I do think it is going to play a large role in the practice of law. It already is, but it's going to be an increasing role.
What have you seen from day-to-day perspectives from clients and sophisticated clients? I know that you work with a lot of very sophisticated clients, in-house counsel. Are they coming to you advising about their use of AI, or, more generally, obviously, in a general sense, what are you telling people? What are you telling clients? How are you seeing it affect a dispute? And are you trying to preempt use or trying to preempt issues, or is it really bespoke and a case-by-case sort of example?
Yeah, I should be wary about how I respond here. I think it does depend on the client. I think there are a number of larger, sophisticated clients that have their own use of AI up and running already. And then there are more kind of individual clients that are maybe more analogous to the Tate decision, that are just going out on their own and using it. And that, so I think the guidance there is a little different. But then as I mentioned, right, I think there are clients where their guidelines themselves are requiring us as a firm to use AI, right, and or encouraging it. And I think that kind of shows if we're being encouraged from large clients to use AI. The expectation is that everyone is using AI. It's here. I think as far as guidance, it goes back to, as a litigator, I'm wary about what gets put in writing always, right? And there was a partner that I work with who used to say, I don't want anything in writing that would embarrass me if it were on the front page of the New York Times. And I do think that applies in anything, right? So, what prompts you put in and what information you put into AI is probably similar, in the sense of, look, when something is in writing, even if there is an expectation of privilege, the facts matter, the law matters. And if it gets pushed with a judge, you really never know. So there is always that, be aware of what you put in writing always, I guess, is especially when things are marching towards litigation.
Be aware what you put in writing, and be aware what you're disclosing more broadly to AI, to anyone, but to AI, to OpenAI specifically. And we know there's a lot to discuss on this topic, but as we've discussed, the pace of progress in this space definitely doesn't show any sign of slowing. So even what we've discussed today, as you foreshadowed, Ian, may very well be the needle may have been moved again in months to come. So while we do see that courts are increasingly grappling with the implications of generative AI, the law is starting to catch up, but just starting to catch up, and asking these questions about privilege, confidentiality, and disclosure will keep evolving. And I do think that until greater consistency emerges, practitioners should adopt a cautious approach when dealing with privileged material in litigation, as well as in practice more broadly, noting that, as you've commented, the use of AI is inevitable, but it must be safe and appropriate use. And what that means is a question that seems to be changing and to be really examined by the courts and by judicial guidance, specifically this year and specifically recently. So on that note, thank you very much for joining me, Ian, and for sharing your insights on the state of AI in litigation and its effect on legal professional privilege in the US. It's been an absolute pleasure speaking with you. Do you have any other points to raise or any other teachings from Maine that you can provide to us? Or
No, thank you, Lauren. Thank you so much for the time. Hopefully for the listener, thank you for listening, and hopefully this was helpful and entertaining. And yeah, and if there are any bird noises in the background, again, I'm not in the office today, but
it only adds to the ambiance, Ian. It's
Yeah,
adding an
exactly,
extra dimension that we appreciate. So no, thank you. And I think, if anything, this discussion has really highlighted to me that while there is obviously a lot of nuance between the jurisdictions, there's a lot of commonality, and it will be very interesting to see, as I've said, how Australia absorbs and adopts the commonalities and extrapolates upon what the US courts have considered so far, because, as we've discussed, the basis of the privilege between the two jurisdictions does seem to be quite similar. So therefore, one would assume that the addressing of the uses of AI with respect to that privilege could be extrapolated to be used. So I do think it's something we can continue to monitor, and it's a watch this space sort of situation. And I really have appreciated speaking with you, Ian. I look forward to speaking with you again when and if we get a sort of monster appellant decision or a decision in Australia. So thank you again. Thank you for your time, Ian.
Perfect. All the best.
As always, listeners, please get in touch with me if you have any questions about what we've discussed. You can find my details on our website, which is hallandwilcox.com.au, or connect with me on LinkedIn. If you've enjoyed today's episode, then rate, review, or subscribe wherever you get your podcasts. I will continue to issue updates on what is happening with respect to the use of AI in litigation and its effect on legal professional privilege. So stay tuned. Thank you very much.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.